algorithms in the context of the work of the police and the judiciary. Before we do anything here, anything substantial, it might be good that I let you know that this theme and this whole panel was initiated by three people from three different European research projects that had one overlapping theme, which was exactly this: transparency and accountability for the use of algorithms in the context of police and the work of the judiciary. And those three people were, well, Erik Zouave was one of the initiators, Thomas Markeni and Laurens Nauts, certainly not in the least. He was one of the masterminds for the organization of this panel. And of course, we all want to thank them already in advance, because in the end there might perhaps be no time left to do so. So thank you, all the three of you, for taking this initiative. For the rest, I will not say very much. I will first introduce the moderator of the panel, Eva Schlehahn. She is from Kiel, if I'm correct, and working at Data Protection Office, an independent data protection advisory office. I'll give the floor to Eva.
Okay, test, do you hear me? Yeah. Hello everybody, welcome. Yeah, I will be moderating this panel, and we will jump right in a way. We have four speakers, which will have their presentations, each after the other. At the very end of the session, you will have the opportunity to ask questions to each of the presenters. But first of all, we will hear their talks. We begin with Erik Zouave. He's an analyst with the Swedish Defense Research Agency, researching legal aspects of technology and security, and he's also a research fellow with the Citizen Lab, Monk School of Global Affairs at the University of Toronto, Google Policy Fellow, and former researcher with Leuven Center for IT and IP Law. So I'm very pleased to hear what Zouave has to tell us.
Well, thank you very much. And I would like to stress that indeed this work is not just my own. I have the co-author of much of my work sitting over here, and with respect to algorithmic transparency and accountability, Thomas Markeni, and of course with respect to biometrics, Jessica Schroers, who seems to be busy at the moment, which is very understandable because she is indeed a very busy person. And I will be talking a bit about the by design requirements in police biometrics and algorithmic systems. But before doing that, I think it's worthwhile to point out that I am here in two capacities. I've worked on this project myself, formerly with Cpdp KU11, but of course now I am also with the Swedish Defense Research Agency, a defense authority and a research institute. My opinions are totally my own though, of course. The institute, it works in the areas of military, civil defense and security. And as practitioners, as researchers in this area, we can note several things about the way analysis is going, and that's, in our digital society, the role of the internet cannot be understated. It is a place where we form our opinions, where we communicate, where we express ourselves, where we love, and some of us hate, incite, aid, and abet violence and other crimes. This, of course, makes it an incredibly interesting space for police and intelligence agencies to work in. And this also brings about a necessity for legal research to constrain and to inform that work and these developments. So, what is the area in which the DANTE, VALCRI, and Victoria projects are working? Well, I've said this before in this conference. It is an area where increasingly personal data is collected from public fora, and particularly the internet, but also from other agencies, from CCTV cameras, etc. They're stored in silos, put together, analyzed to infer suspects' physical, physiological, and behavioral characteristics, bringing about increased amounts of data, heterogeneity in data, and technical complexity in the sources of data and the automated processing techniques that are used. What does the law say about this? Well, there are certain things that should be considered for projects like this, and that is that the systems, the pilot systems, and the research building up to a pilot system is generated under the Lex Generalis regime and the research paradigm of the GDPR. But the systems are then to be used under the Lex Specialis regime of the DPLED, Directive 2016-680, which regulates police use and police processing. And in this area, you also have instruments spanning both of these paradigms, the EU Charter, Convention 108, for example. And these instruments, they have a common approach. Irrespective of the paradigm, they have a common approach to the concept of automation, both with respect to biometrics and also generic automation. And we find this approach in the definition to processing. The definition to processing, the one you see on the screen, an operation or set of operations, whether or not by automated means. Thereby, it is accepted that it can be automated. And what exactly is meant by this? Well, going into the interpretive materials, both for COE and EU law and the recitals, we find that it has to do with logical, mathematical, arithmetical operations and statistical inferences. So, EU data protection law, COE data protection law, directly regulates algorithms. It directly regulates the probabilistic statistical inferences and similarities that are drawn when matching biometrics. Biometrics then. Well, it's actually a type of personal data. What the law speaks about is biometric data that results of a specific technical processing. As such, it is not a processing technique per se, but it is something resulting from a specific technique to derive information on physical, physiological, and behavioral characteristics in a way where we can allow or confirm unique identification in the police context of a suspect, sorry. But we shouldn't take the idea of unique identification too seriously. It's something that sounds very strict, but looking at the interpretations, you see that actually it's a matter of probabilistic inferences about characteristics, or what the law would call identifiers that are peculiar to the data subject. When we are in the realm of behavioral analysis and automation, we're also talking about profiling and automated processing on personal aspects with the purpose of evaluating or analyzing or predicting preferences, interests, reliability, behavior, location, and movement. As such, there is a considerable overlap between these two. You have probably heard several times within this conference already of the requirement to mitigate the risks, the varying risks, and to put in safeguards by design in systems. Well, the same applies in policing. However, I think that the most clear clauses of the law, they appear within Recital 71 of the GDPR. What must we do? Well, we must apply suitable safeguards that include specific information to the data subject, such as the right to obtain human intervention, ways to include means for them to express their views, explanation of the logic involved, so that they are able to challenge decisions coming from automated processes, the process itself must be based on appropriate mathematical or statistical procedures. We must have both technical and organizational measures to reduce inaccuracies, to correct, to minimize the risk of errors, and to prevent discriminatory effects. So how can this be mitigated? Well, I've been asked to talk specifically about transparency in this respect. There are some differences between the GDPR and the Lex Specialis, the DPLED. And of course, this affects in which light we must read recital 71 with respect to Lex Specialis. So, for example, there is a system built in whereby a supervisory authority must be consulted after an impact assessment is done in certain cases. This is particularly relevant for cases like biometrics and profiling. Information on the categories of data, including biometric data, must go out to the data subject in certain cases. Information on the profiling exists, but it only exists in the Lex Generalis case. However, we can here refer to Article 13.2, whereby police authorities also must provide further information in order for the data subject's rights to be exercised. Explanation of the logic involved. This is also missing in the DPLED. However, recital 38 is something we can reference here, and the need for specific information to obtain human intervention and express the data subject's views, or to facilitate the data subject to express their views. And of course, in the end, remedy and redress. Now, these observations have been made. For example, that we can read recital 71 in the light of Article 13 and recital 38 of the DPLED in a recent opinion by the Article 29 Data Protection Working Party, which is referenced as WP 258 on the directive. However, transparency has its conflicts. For example, while it is also necessary for police and law enforcement agencies to keep records of their processing, in order to make the logic and the logical basis of the system more explainable, it might be necessary to have data provenance, to have records of where the learning data for the system was taken, why it was chosen, and what type of interventions were placed on that data before the system got to learn from it. However, what about systems that continually learn? And what does that mean for limiting associated data to biometric data so as to minimize and make the processing proportionate? How does that bring about challenges in limiting the biometric matching, for example? Does it become so that more actors within an organization can surmise what is in a template? Possibly. Transparency and explanation. Well, we must keep the templates secure, the biometrics templates secure, and we must make the collection secure, and we must ensure that the algorithms used for biometrics cannot be spoofed. Of course, here the Article 29 Working Party opinion says that, well, in the case of legal redress, we might actually have to explain our algorithms to a court of law, or to a data subject, or to a supervisory authority accessing the rights indirectly on behalf of the data subject. Then we must consider exactly what can we explain. How can we live up to this standard without prejudicing the security of our algorithms, so that we can keep them accurate, so that they cannot be spoofed, so that other third parties cannot surmise what we are collecting on people. And again, this comes back to oversight and the oversight and redress problem. So with that, I would like to give back the floor to Eva.
Mr. Zouave, many thanks for your interesting presentation. Before we move on to the next presentation, I would like to let you know that, again, that there will be the possibility to ask some questions later on when everyone has presented. However, I'd also like to take the opportunity to ask one question right away by myself. Mr. Zouave, in your presentation, you explained what would be the subject of transparency and who's its advocacy, actually. But in the law enforcement sector, there are naturally limits to transparency. Also, exemption cases in the law enforcement directive regulated. An example could be cases where the police does not want a suspect to know is being investigated. Do you think the legal requirements laid down in the new framework cater out this partial lack of transparency sufficiently enough?
In my opinion, yes, they do weigh the issue of confidentiality and secrecy that is necessary in the law enforcement context. For example, while the regulation has the provision for lawfulness, fairness, and transparency, the directive has the provision for lawfulness, fairness. Transparency isn't there initially. It's something you have to read in through statements such as natural persons should be made aware of risks, etc., etc. There's also the possibility for delaying, restricting, or omitting information to data subjects on the basis that they might prejudice legal inquiries, etc., which is something that occurs in Article 13. Again, you can also reference Article 17 here, and the possibility that data subjects should exercise the rights indirectly through a supervisory authority, one that can be more privy to the information within a law enforcement agency without prejudicing the operations.
So there's a whole set of opportunities there to gain some transparency as well. Thank you very much. I would like to move on to the next speaker, Mrs. Penny Duquenoy, which is Associate Professor of Ethics and IT at Middlesex University in London, in the Department of Computer Science, with a research focus on embedding ethics in the design and development of ICT. She has led and participated in EU and UK co-funded projects focusing on ethics, some partnering with police, for example in the VALCRI and some I2 ISIS project with focus on child protection, the latter one, and participated as a member of ethics advisory boards for UK and EU projects over the last 5 years. Penny undertakes ethics reviews of EU projects and proposals for research agencies in Europe, Canada, and US on ethics, social impact, and privacy. Well, very keen to hear what you have to tell us.
Okay, thank you. Thank you, Eva, and hi, everyone. So this section gives the ethics perspective on the projects. I'm particularly been working on the VALCRI project, so the logo is up in the corner of the slide. I'm looking at the invisibility and transparency and accountability. That's that. Okay. Invisibility, which is the opposite of transparency, has been the most influential, I think, driver of my research and my thinking about ethics and computer systems. I've been working in this field for a very long time, did my PhD on it. And this influence is from James Moore, who identified invisibility as the reason why we need to think about ethics in computer systems. This was quite new at the time, and ethics or computer professionals were saying, well, we do ethics, we design good systems, why do we need to think about this? He pointed out that the reason why we need to think about this is because largely what happens in computer systems is invisible to most people. And because of that, there are some risks. So invisibility of actions and rules, let's say, that are behind the system can lead to all sorts of consequences. So one of those is invisible abuse. And if something is invisible, or if people could be invisible, there is an opportunity to do wrong, to make the most of that invisibility and not be found out. So with computer systems and people who know how they work, there is some opportunity to exploit those systems. So we have invisible abuse in all sorts of ways. We have invisible programming values. Every system that has been designed has got a set of values. These come in the requirements, and those values can change and come, and some may not necessarily be ethically significant. But they do have values, and the designers, the users who are making their requirements may not quite appreciate what those values are. Those values become embedded in the coding, in the design, in the requirements, and may not be obvious until the program is running and somebody might be affected by them. Finally, we have invisible complex calculation, and I think that's been well recognized in the last few years, particularly with the focus on algorithms. But even before then, computers are complex things, and when they are operating, it's not quite clear, certainly to most end users, why things happen, what might be happening. So we are working with systems. We're not entirely sure what's happening behind the scenes, and that can prove difficult and challenging. So if invisibility is challenging and can pose some problems and opportunities for misuse, certainly in police systems when we're designing them, we need to counter invisibility and address those problems. And of course, transparency is the opposite. So we want to encourage transparent systems. This clearly, an entirely transparent system would be overwhelming and would make it unusable. In police systems, transparency can pose some challenges because you need to keep some things not transparent. You need to keep some information separate. But as a general principle, we've been working to have the system operations transparent, to make it clear, or to have some auditability over the operations, so that the police know what they're doing, and so it's clear to avoid this invisibility problem. Yeah. So ultimately, police systems are trying to prevent crime. They're trying to find people who commit crimes and bring them to court, and their evidence that they are using needs to be valid and to be seen to be valid. So you have to have some sort of trail to show how you have come by this evidence that you're accusing this person with. Part of the project then has had a work package on human issues. Part of that were the legal aspects, but also the ethical aspects. Trying to get ethics into the design of the system, which is exactly where it needs to be as the system is being developed. These aspects need to be considered and put into the design process. This quote, again, another hugely influential piece of work for me, is every technology artifact is doing something that we would, as people, otherwise be doing. These are mediating, these systems are mediating work that we would be doing. And if in our work we need to conduct ourselves properly, check facts, make sure what we're doing meets ethical standards, then the systems that we're using to act on our behalf also need to meet those standards. VALCRI is the project I've been working on. It's police system for police use. It's mostly the focus is on the visualization of data aspect, and the link on the slide is to the web page which explains this connecting the dots. So police are faced with huge amounts of information in lots of different formats, lots of different types of software that they are switching between one and another, and this interrupts their sort of flow of work. So I'm sure most of you have had experience of working with something. You're asked to provide details on or a report about something, and you're switching between, I don't know, Word, Excel, graphs and pictures and all sorts of other things. And then this is very disruptive with the thinking process. So the VALCRI project is about designing the front-end interface that is much more usable. But of course, behind the interface, as I've already said, we have a lot going on, and the information that is being fed into that interface needs to be clearly thought about. So we need to build the system with the values in mind, with ethics in mind, to make the system transparent, and to work with the police on their values and find out from them actually how their processes at the moment can be transferred into the system that we're building. Thank you. So we're addressing, in technical terms, one of the biggest difficulties, of course, for the lawyers, I guess, as well, as ethics people, is saying, okay, well, you need to design a system that doesn't do harm and protects people, and the technology developers are saying, okay, how do we do that? So you have to translate what you're wanting them to do into some practical implementations. So to address invisible abuse, for example, logging changes to the system. Okay, you've got security measures that hopefully would prevent unauthorized access, but should something happen, you've got logging measures, and if the end users know that their activities are being logged on the system, then this can serve as a deterrent. Feedback processes can help with programming values, so discussions with the technology developers, to check back, explain, have discussions. Algorithms for the invisible complex calculations aspect are a particular challenge. But one of the helpful things we had already in the project had already implemented most of these guidelines, let's say. I'm getting Eva telling me I need to move on. In fact, we've checked against these guidelines, and I must say they're very useful, and we have them. Okay, finally, anything you build thinking of values needs to meet the values of the institution. Okay, done. Thank you.
Thank you, Penny. Penny, at one point you talked about the invisibility factors by Moore, which is something you also brought in as a ethics requirements in the VALCRI project we are both working in. Could you explain to the audience why these factors are so very important, especially with regard not only to the question how personal data is being processed and for which purposes, but also how to explain how decisions are made based on this data?
Yes, so how data is being processed and how decisions are made, and why addressing invisibility is important. Generally it is. I'll speak about police systems though in particular, because we're talking about people who may be in trouble with the police, who may be a suspect, and it's absolutely crucial that how a decision has been made, well, how getting to the point of somebody being a suspect, how that has happened, and then the decision to proceed with various courses of action. Those decisions have to be made visible as well. The process of each step needs to be processed because, yes, it would be wrong totally for a system to put all this information together and then say this person did it, and that would be the end of it. So it's important to know exactly how the decision was arrived at.
Thank you, Penny. Well, I would like to move on to our next speaker. Dr. Joachim Klerx has been working in the field of political information system and horizon scanning for more than 15 years at the Austrian Institute of Technology. His main focus of research is currently in the management of innovative networks in foresight and horizon scanning centers.
Thank you. I will talk a little bit about what does it mean to apply these systems, what does it mean for society. And the dilemma, in fact, is if you are looking for patterns to identify terrorist activities, then you apply a system on a society where almost all of the society is not in the target of the system, but only a few people are. So how to develop a system without interfering the rest of the society? I will explain a little bit the core principles of regulations, including the upcoming regulations. Then I will show a little bit the practical stuff we are working on, and give an outlook about future development perspectives. So we already have heard about the GDPR regulation. In addition to this, there is the new GDPR is starting in May 2018. And there is a discussion in the European Parliament about the e-privacy directive, whereas the GDPR is about lawful processing of personal data. The e-privacy directive is about lawful processing of communication and metadating. Both of these affect us, and I will show a little bit how this does affect our analytics. So if you think about terrorism, then you should think about political motivation. You have a legal part of political activities and an illegal part. The legal part is, well, you can do, you struggle for power. Every party does it. Maybe you put in place propaganda, you do charity, you like to establish social values. This is all what legal political parties are doing. And then some of the activities are more going into an illegal part, like you do not just propaganda, you put in place fake information. Is it legal? Is it illegal? Sometimes. You do dirty campaigning. Some parties do it. You engage in hate speech. Maybe you engage in corruption. Then it becomes more illegal. On the other side, the terrorist fighters do the same. They have a political motivation. They struggle for power, but they use illegal methods to struggle for power. They generate fear. They plan and operate terrorist attacks. It's obviously illegal. And we try to identify this, but identifying this does mean that we look at both political activities from the legal side and from the illegal side. And it's difficult for systems to make the difference. So you can find charity on the internet, but is it charity from a legal organization or is it from an illegal organization? Often you do not see the difference. I will show more practically some stuff. Here you see on the left side a map of the G20 countries. Then you see on the right side a map of the Islamic Caliphate. Within the homepage where the map was shown, there's a discussion about that the Islamic Caliphate feels threatened by the G20 countries. So think about, is this discussion legal? Is it illegal? If you look at the organization involved in this discussion, you find that these organizations are involved in planning and organizing terrorist activities. You see here in the bottom of the picture a pattern of global distributed terrorist activities. These terrorist activities take place at the border of the Islamic Caliphate. Does it mean that the people are planning it? Probably not, because there's not a single organization planning the Islamic Caliphate. But these are the difficulties of interpreting what you find on the internet when you're looking for terrorist activities. So which methods are used to identify terrorist activities? There are methods to de-anonymization and tracking. You see here the development of different methods over time. It's about 10 to 20 years time frame, starting with IP addresses, MAC addresses, and ending up, and this is from a developer perspective, in finally you can use any pattern which is typical to a person. So there are, and the upcoming regulations are, for example, about cookies. But think about that your browser history is unique to you. Then you can use the browser history to identify you. And this applies to almost all things you have in your computer. Everything which is typical to your pattern might contribute to identify you. So what software is used by law enforcement agencies? There are basically two main products, the Palantir and the IBM project. What we are doing in our research project is we develop methods, algorithm, big data, analytics algorithm to collect the data which can be used in these systems. So what does this mean for the future? We have heard about the data protection. We have heard about transparency of code, which is very important. If you think about society and about that police can either be helpful to society or threaten society, then it's very important to think about how police work can build up trust in society. This means that the work of society, on the one hand, the work of the police on the one hand should be transparent to society. On the other hand, if it's too transparent, then it's not effective because the people you are looking for know how you're working. This is a dilemma. So, but for development, this means you need not only if you ask developer how to develop code, then they do not think about data protection or society. They think about how to find the solution to their problem. So this is the reason why you need in people like Erik or Penny to think about what does it mean for society if you start to do this and apply this technique to practical work. Thank you very much.
Okay. Yeah. Thank you very much. I have a question. To combat radicalization and terrorism, law enforcement agencies focus, as you told us, on the use of technology to gain insight to the personal information of potential suspects. Examples are predictive crime analytics using statistics and forecasts approaches, or even so-called prescriptive analysis, offering advice on tactical or operational activities. It's a difficult word. Letters from words, words from sentences. Operational activities. So, now I got it. What is your opinion on the maturity and effectiveness of such technologies, considering the impact of base rate fallacies and other errors?
Well, the predictive crime analytics was successful in the last years to put police resources to distribute them effectively in certain areas, for example. But from my expectation, the results are only for a short time, because if you think about the more intelligent crime people, they will adapt to this. And if they know that the police work and think like this, then they will change their behavior. This is included in the prescriptive analytics. Think about what the other are doing and do your strategic planning according to the strategic behavior of the other one. I will go one step further. In foresight analytics, you think about this in a systemic way. If you behave strategically like this and the other behaves strategically like this, how can I win this game? And for me, the expectation, and this is what we do in foresight analytics, how can, and in the last years, it was almost that the organized crime was faster than police. How can we change this pattern?
Thank you
this
very
is
much.
idea from foresight analytics.
Well, thank you, Mr. Klerx. I would like to give now the opportunity to Christian Wiese Svanberg. He's the Chief Privacy Officer and DPO of the Danish Police. He is experienced from the Danish Data Protection Authority, the Danish Ministry of Justice, where he co-chaired the expert-level negotiations in the Council of Ministers on the GDPR and the Law Enforcement Directive in 2012, and as a practicing attorney at law and personal law firm in Copenhagen. He is the author of several academic articles on data protection law, including The Illusion of Harmonization, published in the Cambridge Yearbook of European Legal Studies. Christian is an external lecturer in European data protection law at the University of Copenhagen, where he graduated from law in 2003. He also holds an LLM degree from the University of Pennsylvania Law School.
Thank you, Eva. Well, I actually want to start off with picking up a point that Joachim made. I think I agree on the point of working with developers, with the ones that supply our systems. I think that is definitely proven within the last year. We're making very big inroads in Danish police and trying to modernize how we work with data, and that has definitely proven to be a crucial point in having a very active and continuous dialogue with the vendors that provide the systems that we use, in order to make sure that we're asking the right questions of them and they have the right understanding of how we function. And also to the point on the balance of transparency, I think it's, and I'm going to get to that later as well, but the tension, you could say, that you have between obviously us keeping our investigative methods confidential to some extent, but also on top of that, you're always going to have the situation where at the end of the day, what we do is supposed to end up in court, in a public hearing most of the time, sometimes in closed hearing, but still in a transparent process where the rules of criminal procedure will force us to be fairly transparent about how we use data. For the Danish police, this is we're not really using algorithms yet, I would say, but obviously this is happening once you start really getting more knowledge about what data you have. I won't rule it out, but it's something that we're aware of, how we actually can use this and how we also prepare to think about being accountable and transparent once we get to the courtroom. Because unlike other services that might exist in the government entities, we still always have to be aware of having to be asked to provide the reasoning why we're presenting something as evidence. So I think that's a very good point that Joachim made. Right, let's see if I can get this to work. Right, I think coming as both a lawyer and also from a practical point, I think I want to stress the point that sometimes seems to be lost sometimes when you move in data protection circles, is that you sometimes get the sense that some people think that we're the bad guys, and I think one of the things that are important from recent ECJ jurisprudence is that it basically recognizes that we actually have a particularly broad and fundamental legitimate mandate when we operate as law enforcement. That's based on many different reasons. The one that is most clearly expressed by the court in the rulings of digital rights, Tele 2 and the Canada PNR, is obviously that we seek to prevent serious crime. We're protecting the basics of democratic society and public order and safety. So I think that is always an important point too. When you talk about something like algorithms, the standard is different, I would say. It's not the same as when a commercial entity does this to sell you a nice sofa or some orange juice. We're doing this in a way to, as Joachim said, to deal with the rapid involvement in criminal activity, the more advanced threats that we face in relation to cybercrime, organized international crime. It's very much more complex, and that is pushing us into being able to think in these new ways. And I think it's important to say that even though the court has obviously expressed some criticism about certain elements in these cases that I cite here, it still also fundamentally says that we can actually do this, unlike other entities, in order to solve our tasks. So that's sort of a basic framing, I think, that is important. So the basic question that Joachim also touched upon is, well, can the need of law enforcement to retain confidentiality of our investigative techniques, can that justify that we actually protect the actual algorithm that we might be using? So the classic black box scenario effect on an individual. One of the things that we took issue with in the Article 29 Working Party guidance, the draft guidance that was issued a few weeks back, was that they use as an example the situation where someone crosses a border and is stopped at a border checkpoint and is then refused entry. And that was used as an example, that's at least how we understood it, of a decision that could be based on something other than on solely automatic means, giving rise to the question of when is sufficient human involvement in place, and all the other elements of the concept of automatic decision making in the Data Protection Directive and the GDPR. But I would argue that is actually not a decision. If you are, in most cases, if you have refused entry into a EU member state, that is a result of a decision that has already been rendered somewhere else. You have been extradited. You've been given you've been prohibited from entering the European territory for whatever reason. The actual refusal of entry at the border is just the execution of that decision that has already been rendered. So I think it's important to be, going forward, as lawyers, academics, experts, be very specific about how you when is this actually triggered, when is this standard applicable. I think the co-legislator was very specific in saying this is about decisions that based on the solely automatic processing is being rendered. Here someone searches in databases and finds out that this individual in front of me has, under due process of law, in accordance with national law, EU law, whatever may be applicable, has at another point in time been rendered a decision that he cannot enter. So that is, I think that's an important point, just to illustrate how we need to be very aware of when it is actually applicable. And then you could ask a ton of different questions. So what about something like automatic traffic controls? Would it be enough to meet the standard of human involvement if just a caseworker reviews the photo of the speeding motorist, if that's the case, and approves the fine? Well, I would definitely say yes. That would be a sufficient level of human involvement, just from a practical point of view. Just to illustrate the kind of issues that we're probably more concerned with. This is, what does this actually mean in practice when you talk about the concepts that the GDPR and, of course, also the directive has implemented. And just to round off my brief remarks, I would say, and maybe also to be a little bit critical, from my point of view, as someone who's worked in data protection since 2003, I view the Directive 2016/680, the Law Enforcement Directive, as being much more groundbreaking in many ways than the GDPR. The GDPR is an evolution of 9546. We know the rules. Yes, there are involvements, there are higher fines, there's some new rights, but materially, substantively, we were not caught by a lot of these rules under the existing framework decisions. So this is new, and this is criminal procedure. This is where the citizens meets the state in regards to law enforcement, and here comes the critical point. There's a strong need for guidance. And you could probably, to be fair, I'm slightly disappointed that we're now almost 2 years in since the adoption of both the GDPR and the directive, and we have yet to see real guidance from the Article 29 Working Party on the directive. There's nothing. Apparently at November meeting they adopted a paper. I haven't seen it being published yet. And as far as I can tell, there was no hearing about it. There was no Fab Lab about the the directive, and this is all new. There are thousands of authorities across Europe, law enforcement agencies, that are struggling with what does this actually mean, because we are different. We are not like all the other entities caught by data protection law. So unlike what is stated in a footnote in the guidance on profiling, where they say, well, the same concepts are used in the directive, so this does also apply to law enforcement. Well, I'm not sure I agree. I think we're different. I think the basic premise of what we do, because we're covered by different legislative rules already. There's procedural guarantees. There are judicial review. We're a public authority. We have a much more solid legal basis, and we're also tasked with doing other stuff than selling things or running a business. So I think there's a strong need for dedicated guidance, also from academics. So I think I would just like to say it's good to see that there are a lot of people interested in this subject area, but we need more, and we want to have a dialogue where law enforcement is part of that dialogue. So that would be my closing point. Thank you.
Yeah, thank you very much, Dr. Svanberg. As Chief Privacy Officer at DPO, you already talked about a little bit of the practical sides of things. As you know, the Law Enforcement Directive now requires also a data protection impact assessment from the controllers, where in cases where high risk to the rights and freedoms of natural person appears likely. However, this is a fairly new requirement in the law enforcement sector, and so I would like to know from you, what are the challenges you are facing as a DPO when addressing this?
Well, I actually touched upon it briefly before, but the main issue is in practice is when is this actually needed. So I appreciate the fact that we've already gotten some guidance on when is the high risk standard met, but from a practical point of view, actually figuring out, because often what you will have in the day-to-day work would be someone maybe installing some more cameras, or maybe using drone-based surveillance in a new way, or so often you're struggling with when is actually the threshold for when you need to carry out a data protection impact assessment. So even though the rules have applied to us for a while, we've actually just run across more scenarios where we decided that it wasn't necessary than when we did feel that we had to do it. So I can't really give that much specific practical examples, even though the rules have been in force in Denmark for 9 months, give and take. But just from purely, again, stressing the need for guidance and something that is very specific, because I think some of the things we do on a day-to-day basis, if a private company was doing it, they would definitely need to have a data protection impact assessment. But we have automatic license plate readers and cameras, and of course we have DNA databases, and so for us there needs to be a different threshold, and where that is the initial practical issue we have.
Thank you very much. Well, we have heard a lot of different talks, and you also have now the opportunity to ask some questions. There are some microphones there. I see a question there. Several ones. I think the person in the last line that speak loud and clearly. Microphones are on the way, hopefully. That one? Okay. I will come to you so everyone can hear you. Please speak loud and clearly.
Hi, Niels Leopold. I'm advising the German Bundestag on questions like this for the Green Party. I have a question for Mr. Svanberg. Thank you very much for your presentation. It was interesting. The most interesting sentence for me was, except for we use the info as evidence or merely as an investigative tool. So the differentiation, merely as an evidence, merely as an investigative tool, using the info and trying to differentiate at that point. That is, of course, I think the thing to discuss, aside from some other questions, which data can actually be put into the systems and all of this. So it would be nice for you to elaborate on that a little bit. And my second question would refer to Palantir being used in Copenhagen. You say you don't use algorithms, so what is the big hype about using Palantir and throwing it out to the media?
Well, that was sort of a legal distinction, at least in Danish criminal law. We distinguish between what you can access and use to inform the course of the investigation, as you are initially figuring out who is actually suspect, who's relevant, where do we need to take this investigation to sort of uncover what has happened. And then the formal concept of evidence, i.e. something that we can present to a court that has the sufficient objective characteristic. That means that we can place emphasis on it in the argument before the court. So distinguishing between something that is just maybe like an indicator of something that might have happened that would require further investigation in order to uncover whether or not that was actually the case. So something indicating that that 5 people were at the crime scene at a given point in time. Well, that could be from mobile phone data. So that won't be necessarily be evidence at the starting point. It would just be an indicator. Maybe the phone has been stolen and it wasn't actually him who was there. So we would need to ascertain in practice, is that actually the case? Was that and then we can use it as evidence, because we're subject to principles of objective investigation and that sort of thing. So we distinguish between the initial sort of information that we use to uncover crime and then what we can actually take to court because we believe we found something that indicates guilt. Does that make sense?
Something that needs to be... okay. So the whole system, like the German federal police, has now started on terrorist suspects, like evaluating them in a range of like green, yellow, red light, and then going on with investigations. That is not something up to transparency to the democratic society, how this system works, to legally to find ways to make it public and all of this. Is just a tool?
No, I think that would be, but I would think that would be different, because there you're doing risk profiling on an individual basis. So that is different from the distinction between. So we're talking about different things. So that's different from the distinction between something that is just relevant information and what is evidence. Here we're talking about something where you are classifying individuals in different clusters of risk, and I think that is definitely something where a level of transparency should apply. That's
never goes to court, right? I mean, it's preventive policing.
Yeah.
You try to actually avoid it.
And that's a good point. But I also think it's still legitimate that you have a level of profiling based on risk. I think that's what the public expects. So if police didn't do that, that would be a problem. We just need to do it in the right way, and of course there needs to be transparency. But obviously it shouldn't be that transparent that the bad actors are able to circumvent it, and that's a dilemma. And in regards to using Palantir, well, I mean, for us, Palantir is not really a question of algorithms to a large extent. It is what we're using them for, at least at the current stage, is just being able to overview our data, which does not necessarily require algorithms in this sense. So they're not doing an actual profiling or anything like that. That software doesn't support that. It obviously enables us to access a lot of data, including data that could have detrimental effect for the individual. But whenever something is flagged, you would still, as an investigator, go through your traditional investigative protocols of checking what is that data. Is that data valid? Is it relevant to this case? Where does it come from? It just enables us to more easily access the data that we already process. So we only use it as an internal system. It's not a data collection system. It is something that we use on existing databases.
Can I just... Can you hear me?
No, but perhaps first have the people in the audience.
Okay, so can I just add that with respect to this gradation, this is something which is very interesting in the design of the system as well, because if you think someone is more suspicious and you get an indicator, you obviously have to up the ante and add layers of monitoring onto that. Now, that's something that brings about, that might trigger this significant effect of the automated effect, and thereby you would want a human intervention specifically in that process, so that there isn't an automated decision to, okay, we see in this text a precursor to something that might be suspicious, now go for the biometrics of the picture. You're saying, okay, we started with a text analysis, but there is also a picture. A human must intervene to decide whether or not that picture should be analyzed by the system, and they must know the basis and rationale for why the system thinks that the picture might be even be interested in the first case. So I would certainly advocate for a stance like that, and I think the Article 29 Data Protection Working Party is thinking something in similar lines.
Jaap Koopman, Privacy and Identity Lab. A sort of follow-up question here. There's generally a distinction between, on the one hand, the investigation of a particular crime by police and, say, the more general enforcement, surveillance stuff happening when there's not a particular case. Now, there's people that argue that actually in the case of a actual crime being investigated, the police have very broad powers to go in, get information, whereas if the law enforcement is actually in enforcement mode, there's actually very little that they can do, and they can do even less, I guess, than individual persons could do. Like, you're not supposed to be police walking around on the street and looking at a particular house if you're just doing enforcement kind of stuff. Whereas if you suspect that this is a person that was involved in a crime, then you're allowed to do this. So I was wondering whether this sort of bears on the discussion that we're having in this panel.
Yeah, I can definitely. I'm not sure I follow the premise of the question. I mean, at least not in our concepts. We would say that the police have several tasks. One of them is the general maintaining order, which is a preventive task that the police carries out, which would entail patrolling and just basically reacting to what happens in society without a specific suspicion. And then you would have this the retroactive action, you could say, where something has occurred and then we're actually investigating a crime that triggers specific rules. So I wouldn't share that distinction, actually. I would just say we're doing different things, but we can still collect data and still access premises within the specific rules that apply. Well, the fundamental point again would be that this is data that we have already collected. So our approach is that, and for now we're only using it for actual investigations. But I do agree, if we're using it for something other than investigations, a different standard would apply. I agree on that. So if we're looking at like, for instance, we're planning a traffic stop, that would be a different setup than investigating a specific homicide, for sure. So if that's your point, then I agree.
My name is Lothar Mazzini from the Hebrew University. My question is actually for Christian, but if the professor from Middlesex University would want to answer, that will be great. Given the algorithmic discussion that was at the beginning of the panel, I wonder what is the role of the DPA within that framework of the police itself, because DPO in that role, because the DPO has an internal knowledge, is supposed to monitor how can he influence the values that the police needs to implement, and how he can monitor it, given that ability to understand the system.
Yes, so the DPO has a very clear role in awareness raising and training, and you can sort of bridge this idea of awareness raising and training as a way of having internal transparency. So of course, in this respect, the DPO, well, compliance with the laws itself, making sure that the systems that the police use are developed within the police, that they are compliant, by design, by means of organizational policy, but also the organizational policy in itself as just as the law, as a guideline for what you can do with the system or what the system can do. So, for example, some concrete technical ways that this might be enacted. Well, the DPO might, for example, push for something like flagging to see that, okay, we have a system, the system is trawling online data. Is the system finding special categories of data? Are these flagged? And to what extent can they be flagged by automated means? And to what extent do we need a human intervention to identify other categories or special categories of data that can't be subject to an automated finding, for example?
I think we have one more time, what time is it?
10 o'clock.
Yeah. So we still have time.
Shall I conclude?
Yeah.
Yeah. Well, let me thank once again Erik Zouave, Penny Duquenoy, Joachim Klerx, and Christian, and of course Eva, and once again Erik and Thomas and Lawrence. Please, can you stand up, Thomas and Lawrence, so that people can recognize you, who organized all of this panel and who initiated the theme. So thank you once again. Thanks also to you, audience, and please go on with the discussion about this interesting theme, and see you back later on in the conference.